Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
أسعد الله أوقاتكم بالخير مستمعينا في كل مكان، ونرحب بكم في حلقة جديدة من برنامج Your Rights مع المحامية جومانا كيروز. وللمشاركة على الهواء وأرقام الهواتف في الاستوديو هي 313-769-6666 من وينزر كندا 519-256-1023، ودائما عن طريق الواتساب برسائل صوتية أو نصية، والرقم هو 313-327-7074. مكاتب المحامية جومانا كيروز تختص بقضايا الإصابات الشخصية من ضمنها حوادث السيارات، قضايا إصابات العمل، الأخطاء الطبية والهجرة والتجنس، وأيضا قضايا الإفلاس والضمان الاجتماعي وقوانين العائلة. الاستشارات مجانية في مكتب المحامية جومانا كيروز 248-557-3645. تحياتنا لكم. جومانا، مساء الخير.
مساء النور، كيفك رامي اليوم؟
الحمد لله، نسأل عنك. إن شاء الله تمام، أنت بخير إن شاء الله.
كتر خير الله. مساء الخير لكل المستمعين، ومساء الخير لضيفنا لليوم مثل كل نهار جمعة المحامي مايكل بانكستين. Good afternoon, Michael.
Good afternoon, Joumana.
How are you doing?
I'm doing excellent. How about yourself?
Doing very good, and thank God for all his blessings. Attorney Michael Bangstein, as probably everyone knows, is the head of our bankruptcy department here in the office. We're going to talk about a number of things today that will interest listeners. We're going to talk about unemployment and bankruptcy. We're going to talk about people who may have received unemployment in error, or who may have received overpayment in unemployment, or who may have misled or misrepresented to the unemployment agency and received money, the interplay between that and bankruptcy. We're going to talk about people who are on Social Security, whether SSI or SSD, SSDI, people who are on food stamps, what happens if they file for bankruptcy? Will their payments stop? What if there is an overpayment from the Social Security Administration? We're going to talk about shutdowns and emergency orders and whether or not, because everybody is afraid that we may be shut down again. We are in partial shutdown right now, but more extreme measures may need to be taken, in that businesses may need to be closed. If law offices end up closing again, does that mean that we cannot represent the client, we cannot file bankruptcy on her or his behalf? We are going to talk about medical bills and how medical providers, hospitals, collection agencies trick people into getting them to pay something on a medical bill. And by doing that, they are really being sneaky. They are extending and resetting the 6 years they would have had to sue someone to pay his medical bill to beyond that time. So there is quite a bit we're talking about. And like always, we welcome your calls and your questions. The number to call is 313-769-6666. And the phone number, or the number for the radio WhatsApp, is the 327-7072. صح رامي؟
نعم جمانة، صحيح.
Okay. 313-327-7074. Okay, I am sorry. 313-327-7074. Thank you.
Mm-hmm.
Okay, thank you so much. That's what happens when you are trying to do 3 things, Rami, at the same time.
Absolutely.
You're trying to think, you're trying to talk, and you are trying to text as well.
الله يساعدك. الله يكون معك.
Okay, no problem. It is a blessing to reach so many people, Rami. It is a blessing to have a format where you can, hopefully, the goal is to educate people so that, they know what to do, what not to do.
Right.
Because the law says here in the United States, ignorance of the law is not a defense. So, Attorney Michael Bankstein, can we talk about if things become more extreme here in the state of Michigan and law offices close, how can we represent someone in bankruptcy, file on their behalf? Walk us through A to Z, assuming the worst case scenario. Then tell us, what are you doing right now to keep our office safe and to keep our clients safe?
Well, the first thing that we're doing is that we're observing the Center for Disease Control guidelines, with social distancing, where I'm doing the majority of my consultations over the phone. So at this point, we've been doing that since March. So there's entire batches of clients that we've done the consultation, we put the bankruptcy together, we've done the hearing, all without me ever actually having met them. Now, we do have a protocol in the office if, for whatever reason, somebody needs to come in, with gloves and masks and such, although we really are encouraging people to follow the Center for Disease Control guidelines. And there's really nothing about the bankruptcy process that actually requires anything in person at this point, in addition to the federal guidelines and the state emergency orders. The bankruptcy court has been operating under its own set of emergency orders since March. So all the hearings are being done over the phone and by Zoom.
So, Michael, I think that what this pandemic has taught us and a lot of other people is that there is a lot we can conduct over the computer, over the phone, and worst case scenario, so to speak, via a Zoom meeting. And we can have these Zoom meetings as well. We are set up in our large conference room and on every computer to conduct a Zoom meeting with a client if the client feels better about it. I cannot tell you how many people I have met, quote unquote, via Zoom, and with which I have developed relationships. Never thought that a Zoom meeting would feel as like an in-person meeting. So we learned that. A lot of people learned that, so much so that a lot of companies now are wanting to do away with one of the largest expenditures, that being the rent. I mean, think of how much the rent costs in a place like New York City, in a place like Miami, in a place like Washington, D.C. And if you can save that and successfully work remotely, that's a huge savings. So what we have done is what we will continue to do. Since the pandemic, through the present and into the future, we have been able to retain new clients that we have never met in person, and we conducted our meetings with them over the phone. They will send us their documents, they will scan them and email them, or they will mail them, or they will drop them. And dropping them is still good, And when we absolutely need, for whatever reason, to bring the client, then we have procedures and protocols here in the office. The bankruptcy courts have never stopped. They had emergency orders. They were like avant-garde. They were like trailblazers in this. And you can file online. You don't have to go in person. The meeting of the creditors can happen either via Zoom or can happen by phone, correct?
That's correct. And I can say the bankruptcy department hasn't been down for one single day since this thing started. And we can continue to do this no matter what happens.
Right. And like you said, you have a lot of clients that you have not had the opportunity to meet in person right now.
That's right.
Very quickly, can you remind the listeners what the cost of filing a Chapter 7 bankruptcy in our law firm is?
I'd be happy to. The attorney fees for a Chapter 7 bankruptcy are $575. Now, there's a $335 fee that goes to the court. In appropriate circumstances, when someone meets certain financial conditions, the court can waive that $335 filing fee, but most people do have to pay the $335 filing fee. There's 2 credit counseling courses that you have to take, one before the case can be filed, the second one after the case is filed, but before you can get your discharge. First one takes about an hour, second one takes about an hour and a half, and those can be done online or over the phone. If they're both done online, the total is $60. If they're both done over the phone, the total is $80.
Okay, very good. Let's take a very quick break, and then we will answer a question we just had via radio WhatsApp, and we will move on to the subjects we want to talk about today.
هل أنت مضطر إلى إشهار إفلاسك؟ لا تأخذ هذه التجربة لوحدك، بل استشر أولا ومجانا مكاتب المحامية جومانا كيروز، وتكلم مع المحامي المختص بقضاء الإفلاس مايكل بانكستين، الذي سيساعدك على التخلص من ديونك وفقا للبند السابع لقانون الإفلاس بسعر $575 فقط. ومن الممكن أيضا أن تحصل على إعفاء من أتعاب المحكمة اعتمادا على عدد أفراد الأسرة ومدخولك الشهري. اتصل الآن بمكاتب المحامية جومانا كيروز 248-557-3645 والاستشارة مجانية.
عودة لبرنامج يور رايت مع المحامية جومانا كيروز، وموضوع الحلقة اليوم عن الإفلاس. أرقام الهواتف في الاستوديو 313-769-6666 من وينزر كندا 519-256-1023 وعلى الواتساب 313-327-7074. جومانا نرجع لك.
ثانك يو رامي. اجانا سؤال عبر الراديو واتساب من الاستاذ جوزيف اللي بده يعرف قديش بده يكون عنده دين لحتى يقدر يقدم bankruptcy. Mr. Joseph asks attorney Michael Bangstein, how much debt should he have before he can file for bankruptcy? What a wonderful question. What a broad question. You know, we never talked about it this way. So I am delighted at the way this question has been put. Michael?
Yes. Now, there's no hard and fast rule as to the minimum amount of debt. I mean, as a practical matter, if somebody came in and said their debts were only $2,000, then my recommendation would be bankruptcy is a little bit too strong a medicine for that. You don't need to use chemo to fight a cold. My general idea in my mind.
Let me interrupt you for a minute, Michael. You can still use chemo to fight a cold. But the disadvantages of filing bankruptcy when the amount is so low, ruining your credit and all of that, would outweigh the advantages. And that's why you would help someone with debt so small to find other ways to repay that debt. That's what you are saying.
Correct.
Okay. Continue, please.
In my mind, I have sort of a kind of a threshold, maybe around $7,500, $8,500 on the low end. Although, of course, you start getting, $8,500, $9,000, $10,000, $10,000 plus with some of the stuff running anywhere from 18 to 31% interest. I'd say on the low end, maybe around $7,500. Although if somebody came in and they were 73 years old on a fixed income and maybe they had, $7,000 worth of debt, I wouldn't turn them away. So it's kind of a rule of thumb. There's no hard and fast rule, but generally you want to be at least 75 or 8,500 before bankruptcy would be the appropriate remedy for you.
Again, this is a general rule. This is a case by case. There is no cookie cutter answer. There is no black. There is no law that says if your debt is this small, you cannot. If this debt is this large. I think Attorney Michael Bangstein is talking about two things. He's talking about, can you file bankruptcy? And is bankruptcy the right solution when the amount is so small? You may be able to file for bankruptcy, but it may be a bad idea because your amount is so small and you will suffer other severe consequences that are not worth it when the amount is so small. As far as qualifying for bankruptcy, Attorney Michael Bangstein, notwithstanding whether the debt is $2,000 or $20,000, is it not the general rule that if your debt are more than your resources and income, then on the face of it, you qualify, notwithstanding whether or not it's a good idea?
If you're talking about the inability to pay your debts over time, that's absolutely one of the criteria.
Okay. So, استاذ جوزيف، ما في قانون بيقول انه في مبلغ معين بدك تتخطاه لتكون مؤهل لتقدم على الافلاس. المبلغ يمكن يكون كتير قليل، بس اجمالا عنده قاعده عامه انه اذا كان المبلغ الدين اقل من 7,500 ل 10,000 دولار، بنحاول نلاقي طرق اخرى نقدر نعالج الأمر بلا ما نقدم إفلاس، لأنه الإفلاس is a very big decision. It's a very incisive decision. It's a very I can't find the word. It's a decision that you don't want to take lightly because you can only file bankruptcy once every 8 years. يعني حتى لو مؤهل لتقدم إفلاسك بدك تفكر بمساعدة المحامي بطرق أخرى، لأنه الإفلاس بيقدر الإنسان يقدمه مرة فقط كل 8 سنوات، والإفلاس بيخرب الكريدت سكور تبع الإنسان. حل جذري، that's what I meant to say، حل جذري. فحتى أوقات لو الإنسان مؤهل، كقاعدة عامة أي إنسان عنده ديون وديونه ما رح يقدر يدفعها وهي بتتخطى مدخوله والريسورسز اللي عنده، بيكون مؤهل يقدم بانكربسي. ما معناتها الحل الأفضل دائما تقديم البانكربسي. ومن وقت لآخر بنحكي إنه أوقات في حلول أخرى. الكونسلتيشن اللي بيعملها مايكل مش كل شيء بيقول اوكي والفايل بانكربسي. اوقات من بعد ما يسمع الفاكتس يمكن يقول بنقدر نعمل debt consolidation او debt renegotiation او بنقدر نعمل بانكربسي او مش دائما البانكربسي هي الحل الافضل. الجزء الثاني من سؤالك استاذ جوزيف، شو بيصير ببيتك وبسيارتك اذا قدمت على بانكربسي؟ بتصور انه سيارتك عم بتقسطها للشركه او هي ليس، وبتصور انه بيتك عندك مورجج عليه، لانه we'll have to answer either way. What happens, Attorney Michael Bankstein, if Mr. Joseph files for bankruptcy and he owns a home, assume with a mortgage, and he has a car, assume with a lease payment or another payment? What will happen to his home if he files for bankruptcy? And what will happen to his car? And does it matter if he files Chapter 7 or Chapter 13?
They are treated a little bit differently, but for a house, for example, one of the things I do when I meet with someone is I ask them, are you on the deed to any real estate, whether or not you consider yourself the owner? And I also ask, have you been on the deed to any real estate within the last 6 years? Because you have to look very carefully at how much equity there is in the house. And when I say equity, I mean, what's the house worth minus what you owe on it? Because in a Chapter 7 bankruptcy, there's only so much equity that you can protect in your real estate. So one of the very first things I do when I meet with somebody at the initial consultation is I determine, is the house safe in a Chapter 7? If the house isn't safe in a Chapter 7 because you've got more equity than you can protect, then we definitely transition the conversation over to other things like a Chapter 13 repayment plan or a debt negotiation. Now, in a Chapter 13, it's a little bit different. In the Chapter 7, if you're over your equity, the amount you can protect, the Chapter 7 trustee could take your home and sell it to pay off the creditors. That's why we won't go anywhere near a Chapter 7 unless I'm able to determine that your house is safe. In a Chapter 13, it's a little bit different.
Okay, and before we talk about the car, let me just quickly translate it into Arabic. So, كقاعدة عامة، كل ما الإنسان عنده equity ببيته أكتر، كل ما إذا قدم Chapter 7 معرض إنه يخسر بيته، لأنه المنطق بيقول ليش بدك تحافظ على بيتك وعندك فيه 50 60 70 40 ألف دولار equity وبدك تقدم بانكربسي وبدك تتخلص من ديونك وقت اللي عندك equity ببيتك. يعني البانكربسي تراستي بيقدر ياخد البيت، يبيع البيت، يرد ما تبقى للبنك، وشو بيبقى ربح بيقدر ياخده ليدفع لأصحاب الديون. سو كقاعدة عامة، كل ما الأكويتي ببيت الإنسان أعلى، كل ما معرض إذا قدم Chapter 7 إنه يخسر بيته، ياخده البانكربسي تراستي يبيعه ليرد ديون العالم والشركات. مشان هيك الكونسلتيشن من الأشياء اللي بينسأل عنها دغري، شو عندك ريل استيت اسمك على التايتل، بغض النظر إذا بتعتبر إنه أنت بتملك الريل استيت ولا لا، اسمك على التايتل. ومن بعد ما يسأل قديش عندك equity بكل ريل استيت، الصورة بتكمل وبيقدر المحامي مايكل بانكستين ينصحك إذا أنت مؤهل للحرة لتشابتر 13 اللي هو حل آخر. جزء من الديون تبعك بتروح والجزء الثاني بتقسطه على 3 ل5 سنوات وما بتخسر بيتك، أو يمكن يكون debt repayment plan. كقاعدة عامة، كل ما الإنسان عنده equity أكتر ببيته، كل ما معرض إذا راد يقدم chapter 7 إنه يخسر البيت، وهون الحل بيكون شيء other than غير chapter 7. الجزء الثاني من سؤالك، شو بيصير بالسيارة؟ What happens to his car if he files for bankruptcy?
Now, a car doesn't tend to be as much of a problem because there's one of two things with a car. Either the car is paid in full, which means it's probably a little bit of an older car, so its value is a little bit lower. Or if it's a more recent car and you're still paying on it, that's the type of item whose value goes down fairly quickly after you purchase it. So you're likely to owe a lot on it. It's just like the house where you say, what is the car worth minus what you owe on it? And that's people normally wouldn't call that equity, but you can think of it like equity. And there's a certain amount that you can protect. That doesn't tend to be an issue with a car because there's a fairly generous motor vehicle exemption or protection that you place on the value of your vehicle.
What if you're making the payments on your car and you're current on that, but you want to file bankruptcy because of credit card A and medical bill B? Can you keep the car? You're going to list it in the proper schedule, but you are not seeking to lose that asset because you've continued to pay on it, and during bankruptcy, you will continue to pay on it. Can you exclude it from being repossessed? Can you exclude it from being taken away from you and sold if you've already paid the car and it's all yours?
Well, if you've paid it in full, then there isn't anybody really repossessing it because it's paid in full. There is no creditor at that point.
And how much is the exemption on that?
The exemption using the federal exemption is $4,000.
So if your Lexus is $20,000 and it's paid in full, you can only protect $4,000. So it's very possible that the bankruptcy trustee will take that car, sell it, salvage some money to repay the creditors.
Well, that's just like how I check to see what the value of the house is. Is the house safe? If you have a vehicle and you say, I want to keep this vehicle and here's what the vehicle's worth, and either I owe something or I don't owe anything and it's paid in full, we figure out what's the value of the car and is that within the amount that you can protect. Now, there's a motor vehicle exemption you can use outright. There's also something called a wild card exemption. It's called the wild card exemption because unlike most exemptions, like a jewelry exemption or a motor vehicle exemption or what have you, wild card is a big block of exemption and you can break different pieces off and use it in different areas. So if you're $400 over your jewelry exemption, you can take $400 worth of the wild card and place that on the jewelry to make it safe. If you're a couple of $1,000s over on the vehicle, again, you can take a couple $1,000s worth of that. And that's about $13,100 per debtor is the max for that.
Okay. Just like depending on how much equity you have in your home, the solution for you may be to file Chapter 13, not Chapter 7. Would a similar logic apply if you own a car and it has some value in it, more than $4,000? Would the solution in order to keep it be filing Chapter 13, a little bit like a home, rather than Chapter 7?
It might be because generally in a Chapter 13, unlike a Chapter 7, where you can either protect it or you can't, and if the trustee, if you're over the amount, they sell things to provide money for the creditors. In a Chapter 13, they're not really taking anything. It just goes to how much you have to pay your creditors. So
in
if you're
Chapter
over
13, it's a payment plan.
Yeah. So for example, if you're $5,000 over your real estate exemption, then there's something called a liquidation analysis in every Chapter 13 plan, that there's a rule that you can't pay less to your creditors in a Chapter 13 than would be available in a Chapter 7. So if you're 5,000 over, if you were a Chapter 7 and you know that the trustee would take that thing and give $5,000 to your creditors, you wouldn't be able to pay less than $5,000 to your creditors in a Chapter 13. So it goes more towards how much you have to pay back your creditors more than actually taking something on the Chapter 13 side.
Okay. We have another question, and we are taking your calls and questions. We have another half hour remaining with Attorney Michael Bankstein from our bankruptcy department here in the office. The numbers to call are 313-769-6666, and the radio WhatsApp number is 313-327-7074. We received another radio WhatsApp message from Mr. Rooney, who asks, I'm getting divorced, so I assume, Mr. Rooney, you already filed bankruptcy, because the next question is, what should I do about my bankruptcy? So he's in the middle of divorce. Either he filed or he's about to file. It's hard for me to answer. What is your advice here?
My advice is, and I'll just back up a little bit and talk about the interaction between the two. And oftentimes that answers the various different scenarios that a person might have. So what happens is, generally speaking, it's better to file for bankruptcy first, eliminate the debt, and then you've got one less thing to fight over in a divorce. Sometimes the divorce comes first. Now, if the divorce comes first, or if the divorce happened recently in time, we have to get a really good look at the judgment of divorce, because it depends on how the divorce attorney handled the debt. For example,
in his case, he is in the middle of divorce. So go ahead. Talk about if the divorce is finished and there are settlement terms. And then let's talk about if someone is in the middle of divorce proceedings.
Sure. So if you've had a divorce, for example, you have to look at how the divorce judge allocated the debt. So if the judgment of divorce says something like, the debts and the credit cards of the respective parties are still going to be paid by the respective parties. So if you had some debt and the judge says you're going to pay the debt that was in your name, the other party is going to pay the debt that was in their name, then that doesn't really have any effect on the bankruptcy. One thing you have to look for is if there was a big pile of debt and the divorce judge said, I'm going to have you pay 40% of it and the other party's going to pay 60% of it. If the judge actually kind of drew some lines and allocated the debt, then that tends to be regarded by the bankruptcy court as a domestic support obligation, which is not dischargeable in a Chapter 7, although it would be in a Chapter 13. So the devil is definitely in the details. When somebody has a pending divorce or a divorce that happened recently in time, we have to get a really good look at what's going on in the divorce court to make sure that we're not doing anything bankruptcy-wise that's throwing off the divorce, and that there's nothing going on with the divorce that would throw off what we're trying to do in bankruptcy court.
Okay, so for those who finished their divorces, that means there is a judgment of divorce, a settlement agreement, so to speak, that the judge signed off to. It turned into an order. If you are going to file bankruptcy after you've been divorced, your bankruptcy lawyer needs to look at your judgment of divorce to see if what the judge said about who pays what as far as debts. That is binding, and that becomes a domestic obligation it's one of those debts that's never discharged in a bankruptcy. So,
well, it's dischargeable. It's not dischargeable in a 7 if the judge in some way allocated the debt in a 7. But in a Chapter 13, that wouldn't keep you from discharging the debt. The Chapter 13 repayment plan over 3 to 5 years. So I definitely, before I would file a bankruptcy, if somebody had a divorce within less than 10 years, I would like to see the judgment of divorce to make sure that nothing that we're trying to do in the bankruptcy court, that it's going to have the intended effect.
Okay. Now, some people want to file for bankruptcy while they are married and they know they're going to get a divorce. Well, one spouse cannot prevent the other spouse from filing bankruptcy, right? Let's say husband and wife are fighting and they are heading for a divorce, and he rushes to file for bankruptcy, and he has a joint credit card with his wife with $40,000, if he gets through filing the bankruptcy and discharging all of his portion of that $40,000 and succeeds in doing that before the divorce, well, then she is in bad luck, correct?
Not necessarily. It's still the fact that although his legal when you file for bankruptcy, you have the option whether you're still together or whether you're separated but still technically married. You can file as an individual or you can file jointly with your spouse. So nobody can make you file for bankruptcy, and you can't make your other spouse file. But if you file as an individual,
but you can also not prevent your spouse from filing for bankruptcy.
That's correct. People don't get to say that you filed for bankruptcy or not. You file for bankruptcy, you're in it. So what happens is if they've got a joint credit card, $40,000 worth of debt, and the husband files for bankruptcy, the wife doesn't, the husband files for bankruptcy and gets a discharge, that the debts are wiped out for him, his legal obligation to pay is destroyed, but not the legal obligation of his spouse. So as a bankruptcy matter, that no longer exists. Now, once they're in the divorce court, it's not impossible that the divorce attorney may say, the divorce judge may say, oh, well, I'm going to allocate some of that debt to you. So generally speaking, even if they're not crazy about each other anymore, if the husband has some debts and the wife has some debts, they might not be crazy about each other, but generally it's in both of their interests to kind of hold their noses and file a joint bankruptcy, eliminate all the debt so that nobody's fighting over debt and nobody has to pay any of that debt when they get into a divorce.
I also would think that if one of the two is sneaky and wants to file for bankruptcy on joint debt, just so that the part of the filing, the person filing is gone, and then they go in front of a divorce judge later, I think a family court is a court of equity. And I think a judge is not going to look kindly on this. He got away paying zero on the $40,000 credit card, and now she's stuck with that. I think a judge may order that she has a judgment of divorce much more in her favor because he's been unfair in dumping 100% of the debt on her in filing bankruptcy.
Yeah, that's exactly why I say you can't always do this, but if they have any kind of working relationship at all and they want to wind this up in a rational manner without cutting off each other's noses, if he has some debt and she has some debt, why not file one joint bankruptcy, dump all the debt for everybody, and then when you emerge out of bankruptcy and you file for divorce, then nobody's having to fight over any debt or get stuck with any debt. That's the ideal. You can't always do that.
Yes, that's what I wanted to. Yeah. You can't always do that, or you don't always want to do that. I do not think, Attorney Michael Bankstein, you're telling people today that always, if one person wants to file for bankruptcy, have the couple always file for bankruptcy. You're not saying that, because we have spoken in the past about circumstances where only one of the couple should file for bankruptcy and not both. And it all depends on who's the debt.
That's correct. That's why I prefaced that with if you both have some debt. Yeah.
So, for example, if you have student loans, if the credit card is in somebody else's name, if the debt is mostly in your name, then you and only you should be filing for bankruptcy. If your wife, if one of the two parties makes a lot of money, then the spouse might not be able to file for bankruptcy, because although he or she is filing singly or alone, they're going to still look at the household income and how much of it is going toward paying the household expenses, correct?
Although interestingly enough, when you combine that with divorce, if they're separated, so if they're not living together, if they're separated, then the court does not look at the income of your non-filing spouse.
But
so
you have to be separated
very details
and not
driven.
in the same household almost, right?
That's correct. Yeah, it's difficult to argue that you're separated, but you're living in the same household. But it depends on whether you're living in the same household.
the reason why you can be separated and live in the same household, and it's happening a lot, and it has happened a lot, and I can see why. Sometimes for practical reasons, like we want to be under the same roof for our children, sometimes for child rearing purposes, for child care purposes, for saving babysitting, and sometimes for cutting down on the expenses of ending up with two households, two mortgages, two rents, two electrical bills, two everything. Yes, you can be separated, truly separated, and for various reasons living under the same household. But for the purposes of bankruptcy, if you are separated and living under the same household, it might be difficult if the other person makes a lot of money not to have that be taken into consideration. So the clean thing to do for that purpose, if you're anticipating filing for bankruptcy, you want your money-making spouse to be separated from you and living outside the home, incurring other expenses.
Exactly. It's not impossible to document that you're living in the same household, but you're separated. But that's would definitely require a lot more heavy lifting, a lot more documentation, a lot more time and effort to be able to show that. Another school of thought is, hey, I know you want to save a little money on the rent or what have you, but if ultimately, being in a Chapter 7 versus being in a 3 to 5 year repayment plan, the money saving option might be moving out. It all depends on the details for sure.
Thank you, Attorney Michael Bengstein. Like every Friday, we talk about bankruptcy for an hour with Michael Bengstein. We still have 20 minutes. The phone number is 313-769-6666. We know when it comes to sensitive issues like family disputes, criminal, and bankruptcy, people prefer to send us messages. And the radio WhatsApp number to send us a message to is 313-327-7074. 313-327-7074. رامي، ما بعرف إذا عنا أي اتصال أو إذا عنا أي مسج، لأنه بدي أفتح موضوع unemployment وبانكربسي.
حاليا ما عندنا اتصال أو سؤال على الواتساب، بس أول ما يوصل رح نبعث لك إياه إن شاء الله جمانة.
اوكي، ثانك يو. مرقنا بفتره وما زلنا مرقين فيها الى حد ما، وممكن نرجع نمرق فيها، ما حدا بيعرف. هي انه كان في بانديميك وفي كتير اشخاص معطلين عن العمل، laid off، وقدموا على الانيمبلويمنت وحصلوا على الانيمبلويمنت. والسؤال اللي بيطرح نفسه هو اذا الانسان قدم على unemployment وحصل على unemployment، هل هو وعلى unemployment بيقدر يقدم على bankruptcy yes or no؟ وهل هو وعم يقبض تشيكس من unemployment agency، هل رح يوقفوا تشيكات unemployment agency لأنه هو مقدم على bankruptcy؟ زيت السؤال إذا هيدا الإنسان عم يحصل على food stamps وبده يقدم على bankruptcy، هل رح يوقفوا الفود ستامبس؟ زيت السؤال إذا إنسان عم يحصل على تشيك من SSI للSSI كل شهر أو للSSD كل شهر ومضطر يقدم على إفلاسه، هل رح يقدر يكمل يحصل على المبلغ الشهري؟ وهل يعتبر SSI payment والSSD payment income for the purposes of bankruptcy? Attorney Michael Bengstein, can you be receiving unemployment checks from the unemployment agency and file for bankruptcy?
Yes, the fact that you're on unemployment does not negatively impact your ability to file for bankruptcy. If you otherwise qualify for bankruptcy, that's not going to negatively affect the bankruptcy, and the bankruptcy will not negatively affect your ability to continue to receive those payments.
Okay, so they are unrelated. They are unrelated. You can be on unemployment and file for bankruptcy. You can be filing for bankruptcy and applying for unemployment.
That's correct. I mean, they still take your unemployment income into account when they're looking at your budget in terms of what your income.
What you get from unemployment is income.
Yeah. So it's not impossible. Someone's Social Security payments will push them up over the amount that you can have left at the end of the month to be a Chapter 7. They might have to be a Chapter 13, but But again, if you otherwise qualify for a Chapter 7, for example, simply the fact that you're on unemployment or Social Security is not going to mean that you can't file for bankruptcy.
Okay, and likewise, and very quickly, and then we're going to talk about the fine nuances of overpayments or payments in error from the unemployment agency and from the Social Security Administration. But very quickly, if you are getting a monthly check for SSI or SSD and you file for bankruptcy, is that monthly check considered income too? Yes.
It is, yes.
Okay, very good. Now, the situation that has arisen and may arise again from unemployment is we know that some people who do not qualify for unemployment have applied for unemployment willingly or unwillingly, knowing what they're doing, intending to commit fraud or not really being clear, and are getting or were and are getting unemployment money from the unemployment agency. What happens if such a person files for bankruptcy and the unemployment agency has already discovered that they overpaid you? Maybe you should have never gotten unemployment, or maybe they made an error in how much they are paying you. Either or, you're left with a balance from the unemployment agency, either because they paid you more, or like you said, we've seen it happen where somebody returns to work and they don't tell the unemployment agency. They make it go another 2-3 weeks. This way they collect, especially if they're getting cash or something, or they have an agreement with their employment, pay me cash the first 2-3 weeks so that they can continue collecting for unemployment. And the unemployment agency, for one reason or another, realizes that it has paid the wrong person who would not qualify or overpaid. And now this person wants to file for bankruptcy. You said to me, Attorney Michael Bankstein, that when you owe money to the unemployment agency, you owe them what you owe them, and they can charge you up to 4 times that amount. If you owe them $1,000, by the time they're done slapping you with penalties and fees, the $1,000 will become $4,000. The $5,000 will become $20,000. Can this person who realizes that they filed wrong, they got the money from unemployment, and they spend it, and now the unemployment agency discovered its error and wants whatever it paid back plus penalties and fees amounting to 4 times that amount, can this person rush and file bankruptcy, and will that amount, the 1,000 and then the 4 times that, the extra 3,000, or 5,000 and the 4 times that, the extra 15,000, be discharged in bankruptcy?
So what the bankruptcy code says is that the original amount of the overpayment itself, sometimes also referred to as the principal, is dischargeable in a Chapter 7, but the fees and penalties and interest are not. But since the fees and penalties and interest, I'm sorry.
Let's use the example of the 1,000. Let's say somebody, fraudulently got 1,000 from unemployment agency, or the unemployment agency paid an error or overpaid by 1,000. The 1,000, and this person decides to file for bankruptcy to get rid of the 4,000, which is the 1,000 and the penalties and fees. The 1,000 can be wiped out in bankruptcy, correct?
That's correct.
The 3,000, which is the penalty and the fees, will not, even if the person rushes to file bankruptcy, it will not be wiped out in bankruptcy, correct?
That is correct. However, what I tend to do, and I've been very successful with this on a number of occasions, is I approach the unemployment agency and I say, well, you guys really just want your money back, right? So why don't we, and the default rule is the principal is dischargeable and the penalty and the interest aren't. Why don't we agree to a swap where we're agreeing to the dischargeability of the fees and the penalties and the interest in exchange for agreeing to the non-dischargeability of the principal amount? Because if you had to choose between paying $3,000 or $1,000, presumably a person would rather pay $1,000 over time instead of $3,000.
In other words, you will be negotiating with the unemployment agency and saying, yes, we know that the 1,000 my client get rid of, and we know that the 3,000 my client cannot get rid of and owes it to you. can we enter into an agreement, please, where you will let go of the 3,000 and we will keep the 1,000 and my client will repay you the 1,000?
Yes, we can, and we have done so on many occasions in the past.
Okay. Before we talk about Social Security and bankruptcy, we got a quick question. This is not a bankruptcy question. This is an unemployment question. So I will answer it quickly. I am not an unemployment lawyer, but I think I know enough to think I know the answer. But Estee Saher, you're the person who asked the question. Do not rely on what I'm telling you, because I think that's the answer, but I do not know that to be the answer. Your question is, if your employer filed for bankruptcy, can you file for unemployment benefits? I think the answer is yes. And I'm going to tell you why I think the answer is yes. Unemployment benefits are based on the last 5 quarters you have already worked in. On the past 5 quarters, you and your employer have paid FICA taxes in. So if today your employer files bankruptcy and you file for unemployment, the unemployment agency is looking at the last 15 months of your work history, what you contributed to the unemployment agency and what your employer has contributed to the unemployment agency, and basing your unemployment check today based on those last 4 to 5 quarters. So the fact that your employer files for bankruptcy today, in my opinion, but I am not 100% sure. That's why I ask you not to rely on what I'm saying. I am almost certain. And in my opinion, that's the answer. Attorney Michael Bankstein and I were talking in preparing for the show that the greatest majority of the time, the law is logical. Every once in a while, it's not logical. It's really illogical. So I'm analyzing this from a logical standpoint, knowing what I know about how unemployment benefits are paid. They look to your work credit history for the last 4 to 5 quarters. We have 10 more minutes. The WhatsApp, these are very good questions we're getting today. The radio WhatsApp number is 313-327-7074. The number to call is 313-769-6666. Attorney Michael Bankstein, sometimes you get SSI or you get SSC and you want to file for bankruptcy, and you already said one does not exclude the other. You can be getting SSI payments or SSD payments and decide to file for bankruptcy. Or you can be in the middle of bankruptcy and start getting payments from the Social Security Administration for SSI payments or SSD payments. The question here is, and it's a serious question, is every once in a while, the Social Security Administration calculates your SSI or SSD payment wrong. Sometimes it's your fault. Most of the time, it's their fault. Let me explain. Sometimes it's your fault. If you did not tell them that the income in your house has increased, that means your SSI payment should decrease. That's your fault. But sometimes it is their fault. So let's talk about an SS Social Security overpayment, whether it's an SSI payment or an SSD payment. If the person has received the money from SSD or SSI in error and enjoyed it and spent it and does not have the money anymore, and now the Social Security Administration wants that money back, can this person go file bankruptcy and get what she or he owes the Social Security Administration wiped out, discharged?
A bankruptcy will not discharge your obligation to repay Social Security income overpayment. So nothing on the bankruptcy side will do that. However, there's 3 ways to fix that administratively on the Social Security Administration side. And I'll give you just sort of a brief description of that. There's 3 ways to fix it on the Social Security side. You can fill out Form SSA 561, Request for Reconsideration. That's for when you do not agree that you have overpaid or if you believe the amount of the overpayment is incorrect. There's another form, Form SSA 632, request for waiver of overpayment recovery, that's the scenario when you agree you've been overpaid, but that you should not have to pay it back because you did not cause the overpayment and you cannot afford to repay it.
Okay, so that's when it's likely their fault, not your fault.
Yeah, that's one of those scenarios. The third form is Form SSA 634, request for change in overpayment recovery rate. That's for when you agree you've been overpaid, but you cannot afford to pay it back at the rate the Social Security Administration determined in the notification of overpayment letter that they mail you.
Okay, so in unemployment, if you got overpaid, whatever you got overpaid, you can wipe out in bankruptcy, but the penalties and the fees, which is really what you need to worry about, will not be wiped out unless you enter into a private agreement with them through your bankruptcy lawyer. In Social Security, there is no way. You can file all the bankruptcies in the world. You will not be able to wipe out, because you spend the money, what they overpaid you. But that's generally speaking. But if you can take advantage of one of the three forms, which are on their Social Security Administration, and it's in one of our blogs, when the Social Security overpays you, depending on your scenario, either you disagree and that's Form 561, or you agree but it's not your fault and it's Form 632, or you agree and it may be your fault and it's Form 634, and you want to enter into another payment plan that you can afford, because the solution is never to file for bankruptcy. Correct?
That's correct. That's the three ways to fix that on the Social Security Administration side.
Okay. We have 4 minutes remaining, or maybe 3. I don't think it's a good time to introduce medical bills. And specifically, maybe God willing, next Friday, we will talk about them. Medical bills. Somebody can sue you on a medical bill for up to 6 years. We see it a lot in a car accident. If the car insurance company does not pay your medical bill, guess what? The doctor, Rami, can you still hear me? Hello?
I can hear you, Joumana.
نعم Joumana, we can hear you. Yes, sorry about that.
I apologize because I lost my whatever it's called that you put in your ears. Mm-hmm. What people do not know is that although an insurance company is supposed to pay on a medical bill, the doctor has an agreement with you, whether you know it or not, that says that if other people don't pay your medical bill, they have up to 6 years to sue you. So we will talk about this in greater detail next time, because sometimes people do things in error that will take that 6 years to 7 years, 8 years, 10 years, 12 years without even knowing. Up to 12 years, actually, right? Even longer, who knows? Without really realizing, because they keep making a little payment on a bill, whether it's a medical bill or whether it's what about credit cards, Attorney Michael Bankstein? 6 years too, no? Yes.
That is correct. They've got from 6 years from the last voluntary payment to sue you. That's correct.
Yes. This is for medical bills. This is for credit card bills. That is why when you did medication for Chase in your previous life, Attorney Michael Bankstein, you'd always encourage people to pay anything on their bill, because it will extend the 6 years and reset it. And some money is better than no money, like you said it.
Oh, yes, absolutely. The system isn't broken. It was built this way. So if someone's calling you up saying, can you pay $20? Can you pay $30? Really, they're resetting the clock on the 6-year statute of limitations if you pay them. That
means they are buying the creditor more time to sue you. So be careful about, here you are excited paying $20 on a $1,000 credit card bill from the collection agency or on a medical bill. What you did not know is that they're doing this primarily not for the $20. Yes, some money is better than no money, but really they're doing it because every time you pay, however little, you are extending the time for them to sue you on the balance for by another 6 years. So that's very important. We're going to talk about that in much greater detail next week, God willing, next Friday. Attorney Michael Bankstein, it's been a great show, a really wonderful show. I thank the listeners. I thank those who send us their magnificent questions. Thank you for your expertise, Michael.
And thank you, Joumana. It's always a pleasure, these talks that we have on the radio.
Same here, Rami. Thank you. And thank you to Radio Sina. And have a wonderful weekend, everyone.